The government recently intervened in a key TAM case against Georgia Tech Research Corporation, Georgia Institute of Technology, and Georgia Tech Research Institute, which allegedly failed to protect controlled unclassified information, or CUI. The case underscores the government's increasing emphasis on legal accountability and cybersecurity, marking a pivotal moment for contractors in the DIB. Julie Bracker, partner at Bracker Marcus LLC, represents the whistleblower in the case. She will now explore the impact of the False Claims Act on the DIB. Thank you for being here with us today, Julie.
Julie, thank you so much for joining us. We're thrilled to have you. And, I'd love to jump right in because I want to make good use of your time. And I actually think this is just going to be a great session for our audience because everything you do, the world you live in, really is so applicable to everything today with CMMC and the really kind of growing efforts to legislate mandatory minimum cybersecurity across the defense industrial base and really other parts of the economy. And from the legal perspective, one of the things I'd love to start with you is what initially attracted you to the False Claims Act and what motivated your decision to switch sides from defending False Claims Act defendants to representing whistleblowers?
Well, that's two big questions, and I'm going to not tell you my entire origin story, but I think it says on the website that my first encounter with the False Claims Act was from the defense side. I had been doing I was with a firm in Atlanta doing mostly defense work of all sorts, and we had a case. So the statute was amended heavily in the 80s. And in the early 2000s, when I was at a defense firm, the first few cases filed under the amended statute started rolling out, and nobody really knew how to handle them from the defense side or the few people who had filed them and the DOJ. We're all still working, the Department of Justice, we're all still working out, how is this going to work when the statute has been amended? The cases had not been filed in a long time. And as they started working with the statute, we discovered that there was a case that had been filed that the civil case had been filed out from under seal, really in order to get some discovery for their False Claims Act case, which was still under seal. And so, when it finally emerged that this was related to a False Claims Act case, that huge ripple through my firm and the other firms that were involved in the case, because none of us really knew there's white collar crime implications. People can go to jail for it. This is when you're in orange jumpsuit territory. People get very anxious. We did not do criminal work. We were not prepared to do that type of litigation, and so I was kind of sent on a quest to figure out what is the FCA, what's it doing, what is this all about, why does this case start with US ex rel instead of a normal caption? Like, we were literally at ground zero, and my quest to learn about the FCA, I was like totally geeked out on the statute. It's a really well designed statute. It's all the way back. It's called Lincoln's Law. It's all the way back to the Civil War, where unlike today, where someone sneezes in Poughkeepsie and we know about it 30 seconds later, if that long, during the Civil War, it would be a long time between rations or ordered contracted things reaching the troops and people back at headquarters finding out that they were defective. And so a lot of schemes were born. I love to read. I'm warning you, I do geek out about this statute. They talk about spaline beasts and which bad horses. They would order uniforms that would show up made of tissue paper. So they were useless. They would get flour, but it'd be full of weevils. And so these people were defrauding the government on purpose. And Lincoln's Law was passed to say it actually says set a rogue to catch a rogue. If you are willing to turn in your fellow bad guys, you can receive a share of the recovery. And what's so interesting about it, qui tam, is how I say it. Qui, because it's Latin, not Spanish or French. so you hear quid pro quo. We actually do pronounce the Q in Latin. And I say tam because I'm Southern. You'll hear qui tam from my more sophisticated Northeastern buddies, but I'm going to say qui tam most likely. And a qui tam statute, they had existed in England. They're pretty, very rare now. But he who sues on behalf of the king and himself is the literal translation of the full qui tam phrase. So this is you come to court as like a witness, and it's a very unusual thing. Eric, if you hit my car, I can sue you for it. If someone sees you hit my car, they can tell me about it, but they can't sue you for it, right? In this case, with the idea that sometimes the king doesn't see everything that's going on, or the government, especially the government, then the witness actually has the right to bring the case and let the government investigate it. So it's always really important to help my clients, the whistleblowers, understand they're the witness in the case, or they're called the relator because they're relating the facts of the case to the government. So they don't control the case. The Department of Justice controls the case. We can, if we have good relationships with the government, if we are we may have an opportunity to advise or suggest, but we don't control it. And so the government is going to decide, just like if you hit my car, I might decide I don't want to take it to a body shop. It's not worth the time, the trouble, and the amount of time my car will be down. So if you want to write me a $500 check, we'll call it done. I can do that, even if the guy who saw you hit me thinks that's not fair. They don't get to decide what's a fair settlement. That's up to the government. So I'll wind you back to Julie in 2004 or 5, who's learning about this statute. The structure of the statute is for the person who has defrauded the government, or the entity that has defrauded the government pays the government back times 3. So it's treble damages, which is huge. Double damages seems, and there's more, but let's just unpack the treble damages. That then the relator can receive up to 30%, so up to a third of the recovery, which would still leave the U.S. with double damages. The attorneys who bring the case are, first of all, you're required to bring it with an attorney. You can't do it pro se because you're representing the government, not just yourself in this case. And the attorney's fees are paid by the bad guys. I'm going to call them that from now on in the rest of this. So it's my white hat. I can't help it. So the bad guys pay my fees. And what's unusual in civil litigation, usually if you get fees paid, it's because you win at trial, right? You have to win at trial to get your fees paid in other fee shifting statutes. But under the False Claims Act, winning includes settling. And Congress did that on purpose because there's a lot of incentive for defendants to settle with the government rather than go all the way through trial and be branded, I defrauded the government. They can still say, well, we don't agree that we defrauded you, but we'll settle this case. And if the fee shifting provision didn't include settlement, we would not get our fees for the vast majority of cases. Most of them do settle, although that's a trend that comes and goes, whether there'll be trials or not. So I think I answered at least part of your question as to
No,
why
you
I
did.
switched sides. I'm sorry.
No, that was fascinating, actually, Julia. We've got all the makings of a great session here. We've got Latin Civil War and some intrigue, and it sounds like, as you said, you've been at it since ground zero, which I think is the historical context and kind of how we got here is super helpful, actually, because it makes it more practical. Because sometimes, in the defense industry, certainly within cybersecurity, the False Claims Act case is suddenly very interesting to, tens or if not hundreds of thousands of contractors and individuals. And so learning about this stuff from an expert, in spoken word versus just reading the cases is I think, a lot more useful. So that creates a great kind of framework for us to kind of move forward and level set for the audience. Because on this topic, I find folks are all over the map around their level of understanding. And so that was super helpful. Is there a particularly memorable case? You mentioned a couple and kind of why you got into the space and how, but now that you've been there for a minute, is there a particularly memorable case from your career that maybe had a significant impact on you or public policy that you can think of?
Jason, my partner Jason, and I have a philosophy that I freely admit is super cheesy. And that is we want to do well by doing good. And I really do feel like, I'm after the people who are defrauding the government. They either knew or should have known that they weren't complying with their contracts. I'm not after people, and I get this question when I go to conferences. What if I just accidentally don't do this one thing? Well, I'm not coming after you. I can't say what the government might do, but that's not the kind of defendant that we target. We're looking for people who know better. And in the cyber fraud context, you're kind of pushing the envelope at this point to say that you don't know anything about there being cybersecurity requirements. So there's that. But a company who's doing its best to try to achieve compliance with the appropriate standards and regulations, they're rarely going to have a whistleblower come knocking on my door, right? The people who are knocking on my door are people who maybe were hired after the cyber fraud initiative was announced to bring a company into compliance as true cyber experts, where maybe their past self audits had been done by Sally, the IT girl, who didn't maybe know the terms of art that are used in the NIST standards, and that it said, I think we're doing this good enough, and gave them, a perfect score. Only to have a cyber professional take a look and go, oh no, 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 oh no, we're probably negative here. And when that cyber professional says that, the company usually says, not always, usually says, oh, we should fix that, right? They may not say let's self-report, which they probably should, because keep in mind, this isn't a technical violation. This is a national security is at risk here. We've already said we need to keep this information safe and contained, and you said yes, I'm doing that, and now you've discovered that you're not. I think if you look at the Verizon case, they self-reported and they were rewarded for that by smaller damages. More importantly, we were able to, go we the U.S. and the taxpayers were able to know and secure that information and be aware of what could have, been exfiltrated, etc. But my favorite case when someone asks me about, we take cases of all sizes. There are cases out there. There are not a lot of firms who focus exclusively on False Claims Act work. There are, a dozen maybe that do this and only this. There are other firms where there's a department, the division, a section that does FCA work, and there's probably, I think, maybe 200-300 of us in the country of people who kind of specialize in this area. But a lot of them start with the premise of, if you're going to crank up the machinery, it's just as hard to win a case. You'll spend just as long trying to win a case that's worth $100,000 as you would a case that's worth $100 million. And to some degree, that's true. But Jason and I feel like that excuses people who are maybe not making $100 million, but who are nevertheless defrauding the government and hurting the taxpayers, and usually hurting their patients. A lot of times these are in the medical context. So one of my favorite cases is one where a lady came in to talk to us who was concerned about just some appalling conditions at a dentist's office. She was the front desk lady, and it was violations of OSHA standards. This guy was slapped an Alzheimer's patient because she wouldn't open her mouth. I mean, truly egregious, revolting practices. And we felt very helpless because none of that has to do with defrauding the government. Somebody should report this guy, but what are we going to do? How are we going to do it? And just as we were about to, refer her over to Department of Health and Human Resources, try to get her to someone who could maybe go close this guy down, she mentioned the fact, and she didn't know any better, that he had told her that when he did a tooth extraction for a Medicare patient or a Medicaid patient, she should bill as if he had extracted 3 teeth. And why he had explained it to her is that insurance will pay for $30 per tooth. Medicare only pays $10 per tooth. So he had to bill times 3 to get the same amount of money. And she hadn't realized there was anything wrong with that. So we were able to bring that case. That case in total was probably less than $100,000, but we shut him down. And so the guy who was out there reusing instruments on different patients not cleaning anything in between and slapping old ladies, we shut him down. So it's one of my favorite cases. It did not, I didn't buy a boat. We didn't make much money, but I really felt like we did a lot of good. We have cases on the other end where it's very corporate. It's almost sterile. It's just money. It's just money. Um, but those fund us to do cases of all sizes. So that's our firm philosophy. We try to do well by doing good.
That's a wonderful mission, and it actually kind of helps explain what you shared a moment ago around the context of good guys and bad guys. And
The rewarding part with whistleblowers is that these almost always are people who are trapped. They've A lot of them don't even realize they're being retaliated against, and they may look for an employment attorney to say, "What do I do? They're giving me terrible hours. Took away my bonus. They're putting me on a performance improvement plan. What do I do? I don't even know why they're coming after me." And you scratch the surface, and it's because you've been the squeaky wheel about fraudulent practices. Some of them know full well that they're being retaliated against for reporting fraudulent practices. Most of the time, they have raised that red flag and waved it frantically. Hey, we can't do this. This is not okay. That would be your cyber professionals coming in saying, hey, guys, we're not a perfect 110. We're probably in negative numbers here. We need to fix it. And then, at that point, ideally, the company self reports and they fix it. But a lot of times, the company um, is all about fixing it until that plan meets cost, and they're not so interested in fixing it. And so you get that war between the operational side of the house who wants to turn in better profits and the I guess I would say the IT side of the house who sees the risk. And I think the Civil Cyber Fraud Initiative is a brilliant effort by the Department of Justice to put some of that risk back on the operating side of the business to say, this is going to cost you in the long run quite a bit more if you don't address and fix it. So
yeah, I think that's a great point because that initiative and others like it, whether it's requiring publicly traded companies to report through the Securities and Exchange Commission when they have material incidents, or any number of efforts across the federal government, I think to me represent what is ultimately the only way we kind of get better in cyber, and that's going to be through mandatory minimum cybersecurity regulation. I think it's clearly the government's role, and it's clear that with all the breaches, that without some compelling reason, many companies won't make the investments. And I think the False Claims Act is one of the tools in the government's toolbox to help with that. And you touched on something, Julie. I wanted to just maybe ask you to expand on a little bit, though, because you mentioned retaliation, and I'd love for you to help explain the significance of the retaliation provisions of the False Claims Act and how they actually protect whistleblowers, because I would imagine most whistleblowers have a lot of trepidation and maybe are not aware of the protections in place.
I always I'm happy to talk about retaliation protections. The difficult part for a would-be relator, and I want to be really upfront about this, is you can't. It's a long-term play. If you come to me and say my company is not in compliance, they're representing that they're in compliance, they've lied in their SPUR score, um, and they won't make these changes. I don't think they intend to make any changes, at least in any kind of timely fashion. They refuse to self-report. What do I do? Um, you know, First of all, you need to make sure you've raised that internally, which could, in fact, lead to retaliation, more retaliation, or the beginning of retaliation. Down the road, when we put our complaint together explaining to the government about the fraud on the government, we can include our own claim or your own claim for being retaliated against. So under the False Claims Act retaliation provision, if a person is affected in the terms and conditions of their employment, so it's limited to employment strikebacks, then they are entitled to double damages, and they're entitled to reinstatement at whatever level they were before the retaliation. It's back pay, it's either front pay or reinstatement, which usually people don't want to go back and they don't want to bring them back. So we work out some sort of front pay for that. And it's attorney's fees paid if we have to litigate that portion, and fees and costs. And it's a make whole statute. So it includes make whole means to, and it's a silly legal way of saying to put you back in the position you were before you retaliated against. So sometimes that includes claims for, you know, pain and suffering / mental distress, what you get put through. Some of my relators, a lot of my relators, because in this particular industry, are able to mitigate their damages very quickly. Competent cyber professionals are desperately needed out there in the world. So they're able to advertise, to get on LinkedIn. They have another job within 2 weeks. Most of most of my cyber relators have not been worried about being able to find another job. And so they don't, my advice is always, should not say always, but my advice typically would be, okay, Eric, let's get you out of there. And get you into a new job. And then you're going to have less retaliation. Just, as far as they're concerned, you're gone, you're away. And you want to do that before the time when they start to realize they're under government investigation and when they start to think who could have been the whistleblower. It's when they start to suspect you of whistleblowing that you'll really see, retaliation stepped up. So one of the worst cases of retaliation against one of my relators was Dr. David Felton, who was a MacArthur Genius Prize-winning physician who literally discovered the psychosomatic connection between brain and body and was able to publish the research on that. He was at Beaumont Hospitals in Detroit, and when he came in, discovered just a tremendous kickback scheme that was going on, and he reported it. And Dr. Felton stayed at the hospital there as the director of research for a number of years while the case was under seal, reporting back to the government what was happening, and under my direction and supervision. And they figured out there was a whistleblower while he was still there, and they began to blackball him in the industry. And that's the kind of thing that it's so difficult to prove. These are conversations that happen on the telephone. They're not letters, please do not hire Eric, he is a whistleblower. They just pick up the phone and say, you might not want to hire him. I just want to say there's problems. And, peer to peer, there are not that many people hiring VPs of research out there. Dr. Felton went from a MacArthur grant, internationally famous physician to the best position he could get for the end of his career and remember, this is under seal, so he can't defend himself. They don't know what's going on, and he can't tell them because the case is under seal and he can't discuss it. And he eventually was able to help first-year medical students pass their preliminary courses at a Caribbean medical school. That was it. That was the end of his career, thanks to his whistleblowing. So, there are cautionary tales. We were able to take that case to the Sixth Circuit and have the Sixth Circuit agree with us that blackballing is retaliation, which was a whole episode during the pandemic. It was my first Zoom oral argument in front of an appellate court. But the protections are there. But what's really important is what you referenced before, getting support from a knowledgeable attorney who can kind of guide you through the process and hopefully get you into a safe harbor before the company figures out what's going on. As I said, in this industry, that's easier than in many. And in this era of this industry, I guess, is a good time to be sliding over somewhere safer. But
I would imagine finding the right attorney and one who obviously knows this space and knows it well. And as you said, in this industry, perhaps that's a little bit easier because it's not a population, that you're picking from sea and sea of people. And it's a pretty well-honed set of experts out there. So that's sage advice for any potential whistleblowers. Is there any other advice that comes to mind around potential whistleblowers who are thinking of coming forward with information about this kind of fraud?
Yes. So, but a lot of it comes back down to that. Like there are so many things in this field that are almost counterintuitive. I have people who call me who say, "Oh, this fraud is huge. I've got already talked to the newspaper. They're running stories on it." Well, you just bought yourself more trouble because there is a provision to the False Claims Act. It was put in place to keep people from reading about, Enron scandal and then filing a case to try to siphon off some of the money when they had no extra knowledge about the case, because a relator is supposed to be a witness to the fraud, who offers something to the government's prosecution, and they're typically insiders. There's a section of there's an asterisk there, but they're typically insiders to the company. And so it's important that it's important that you know that there's a provision to the FCA that says that if a fraud is publicly disclosed, then it can affect your relator share. You'll get a lower percentage of the share, and you can be tossed out. Your case can be dismissed if it's based on publicly available information. Now, there's an exception to that called the original source rule, which says, yes, Eric, yes, there was a big press coverage about this, but Eric was the source of that information himself, so it doesn't count as a public disclosure. But why litigate all that? Like you need to talk to, and I feel like based on my experience in this space, my cyber relators generally are cautious and they've reached out to me before they've done anything like that. But maybe partly because the subject matter itself is so focused on confidentiality. But it's very important early on to reach out to an attorney. And I have a potential relator that I've been counseling since March of this year, who is trying to get the company to do the right thing. And it's a not a cyber relator, but this person has been back and forth with ethics and compliance with the part of the company that's not doing the right thing, and really wanted to give the company a chance to do the right thing. So I'm advising that person, and there's no charge for that. If we do wind up filing something, then I hope to get my fees from the bad guys down the road. But if we can correct the problem, I've done good, right? I'm okay with that. So
Yeah.
I do advise people, call early, talk through it with me. Let's see. I might tell you, you're right, and this is an important thing for us to talk about, is materiality. Um, that Office Space movie with the red swing line stapler?
Sure, sure.
Yeah, there are provisions in government contracts that are kind of at that level. Like, I was supposed to use red swing line staplers, and I didn't. And does anybody really care? That's the question. Would the government have not paid if they knew you violated this provision of the contract? And my husband is in the cybersecurity and data privacy space. And I was very familiar with, I shouldn't say very familiar. I was the plus one at a lot of these type of cyber events for many, many years, but we never thought our um, fields would overlap the way they do now, because I would have told you the Cyber Fraud Initiative was announced in October 2021. And prior to that announcement, I would have told you there'll be a materiality problem with saying, I hired you to design a widget. It's a top secret widget. um, and that's what I'm paying you to do. And as part of that, I told you to keep it secure, but that's kind of an ancillary part of that contract. I would expect the defendants to say, that's not material. That's not why you're paying me. That's like a red swing line stapler. And when the government made its cyber fraud initiative announcement, effectively, and I took this position at ACI's cyber conference and FCA conference both, and the air was sucked out of the room by the defense counsel who object, that what they were saying is they consider these requirements material. Um, that begs the question of whether the court would agree they're material, because remember, we have a higher authority we're ultimately going to be in front of on questions of like materiality. But it's really important to understand, when a defendant says, "Well, if we just don't have two-factor authentication, does that mean we're going to pay the full cost of the contract back times three?" And the answer to that is, I've never seen a company that has decided not to implement two-factor authentication, but did everything else great. That's
Yeah.
weird.
Yeah.
Um,
Yeah.
so your hypo is strange. But if that were the case, then maybe you would make an argument that two-factor authentication wasn't materially part of your cyber security for some reason. And you would get to tell a court that. You would ultimately get a chance to defend yourself on that basis. I probably wouldn't take that case because I would have such a hard time figuring out and expecting the court to figure out how are damages going to be calculated if you've done everything else but this one component. Because the real question is going to be, did you keep it secure? Were you in compliance? And at some point, perfection is not required. That's why I think companies who realize they're not in compliance to the degree they've represented and self-report are in a better position than the ones who come in via whistleblower or some sort of government audit. It's a chance to say, hey, we know better. Now we're going to do better and work with government in a partnership. All of
Yeah,
which
I
is
I think that's a wonderful point, Julie, because my experience, going through many DCMA and other audits and working with companies to put in their SPRS scores is, and I think it's embedded within SPRS actually in terms of where they say, what's your POAM, Plan of Action Milestone Completion Date, is that the government, in my experience, is really just looking to see, of course, they'd love everybody to be fully compliant and have all these controls implemented, but I also think really what they want is to show that you're taking it seriously, you're making an effort, you have a plan, you're making progress. It's being tracked at the right level of the company. It's getting the right level of attention. I've seen more of that than I've seen kind of the hammer approach. I think my experience kind of aligns with what you alluded to around, you will fare better if you're kind of forthright and you're making an honest effort.
agreed, 100%. And I'd say that crosses industries. A company that has made an honest mistake should go work with the government in partnership to fix it and to address whatever comes from it. A company who maybe acquires another company and discovers the acquired company is problematic, same thing. I think the urge to like hide it and fix it is real. And especially if they think it can be fixed quickly. And then they often discover it's not going to be quick and it's going to be quite expensive. And that rule about time and money, you're going to use a lot of one or the other.
Yeah,
So
absolutely.
that's that's when I get a relator. So that's when somebody needs to call me, me or one of my colleagues, and I'll give a little shout out when you're looking for counsel. Taxpayers Against Fraud, now known as the Anti-Fraud Coalition, is the Quitam Bar. So if you look them up, and you can link to them through my website, but you can also Google them. Um, that's the bar organization of Quitam attorneys like Jason and I and our lawyers, and it's a little tricky. If you Google False Claims Act, you're going to get. I say there's very few of us who do this full time, relative to the size of the American bar. There's a lot of people who put it on their website. There's a lot of people who say they've done it or who've maybe done one case, but it's more art than science. There's just so much about this statute that until you've encountered it, it's difficult to guess which way things might shift. And that's where I think we provide much more valuable advice because we've just done so many, and that's been one of the un, unexpected benefits to me and Jason of taking all size cases is I feel pretty comfortable in saying we've been in business 10 years. We've been working together for nearly almost 10 years, 9.5, and we've been working together in this space exclusively for nearly 20. And the philosophy of taking all size cases means I think we've probably done more cases than anybody else in the country in total number. Not recovered the most money, not that's not our goal. I don't object now. my husband would tell you we cash checks of any size. We're happy to cash the small ones and the large ones. So don't feel dissuaded that you can only come to me with a small case. But we really do have a lot of experience in across the country in all the different districts. So look for people on the Taxpayers Against Fraud website. I'd call out names, but then I'd get in trouble for missing someone.
Yeah,
So go
for
to
the
that
ones you
website
missed, right? Yeah.
yeah, and it's
Uh,
not geographically limited. We're literally in every state most at some point. So um,
That's
take a
that's
look that way.
that's all great advice, and clearly in this such a nuanced area of the law, particularly with the overlap when it comes to cyber, it makes sense that you want someone with a lot of experience. And you touched on, speaking of the overlap with cyber, you touched on Department of Justice Civil Cyber Fraud Initiative. And I'd love to just hear from you the impact that can have on contractors in the defense industry and kind of what are the key areas of focus for this initiative that I think, as you mentioned, was started in 2021?
That's right. So from my perspective, it made it suddenly part of my world, right, in my professional world instead of just my plus one social world. And Brian Boynton with the Department of Justice has sort of he talked through types of cases that could be brought under this initiative. I call them flavors. There are three flavors. The one that everybody thinks of, which is really the third, is there's been a breach. So people who want to report that there's been a material breach, there's been, data exfiltrated, that that seems intuitively obvious as a case, right? But there are really two other types of cases, and I've not had a breach case yet. I want to stop the data from getting out. If it's already gotten out, that's certainly a case if someone's covering that up. But there is just failure to comply with the regulations. Remember, you're certifying compliance when you sign into sam.gov, when you put in a request for proposal, when you say to the government, I'm qualified to do this contract. And part of that is that you have put in your SPRS score, that you have supposedly have a POAM back at home. And that you might not be perfect, but you're working on it, and that you're diligent. I mean, one of the things that was striking to me when I started to understand the controls is that it's not a one and done thing, right? It requires constant monitoring, and obviously, I'm in my professional life that means I have to click update when when things come out. But for cyber professionals, being able to look at audit or not audit records of what has happened. I have companies that, and it's been interesting to get the government, the U.S. attorney's offices to, talk them through. No, this really matters. If you're not recording who's accessing, you can't look back and see if there's been a breach. You can, and that seems like just mere record keeping, but it's a very important part of the controls and the compliance process. And that's usually the last thing anybody who's not really serious about cybersecurity does. They don't have anybody monitoring anything. They don't even know if they can monitor it, and it kind of slides downhill from there. So I think that I answered your question, but I'm
Well,
not
I
sure.
think you touched on a lot of the things that are probably core to the impact that can be felt from the DOJ, Department of Justice Civil Cyber Fraud Initiative, and how that could impact contractors. And your point around having artifacts and records of monitoring and actual policies that are updated and who's logged on, who's logged off. A couple things there that struck me is that, again, aligns with our experience in terms of having been through many audits from the government. They want to look back, see that you were doing it. And also, in a breach, to figure out where the attacker had access, what accounts they used, did they move laterally through the network, all the practical, tactical things that you're going to have to figure out under duress. There's a lot of practical reasons to have these records. It's not just compliance related. So it's one of the, in my experience, one of the few times where the kind of the compliance requirements and the day-to-day tactical objectives of cybersecurity match up pretty beautifully, because you're going to want those records and you'd rather have that all organized versus trying to figure out in times of duress during a breach, because you're really going to be on your back foot. Do you have any examples, Julie, around where I'll call it deliberate ignorance or reckless disregard? How is that proven in a False Claims Act case that is focused on DFARS 7012 or, in the future, obviously, cybersecurity maturity model certification, but let's for now maybe focus on DFARS 7012, which has been, it's in well over 1 million contracts, and depending on when you start counting, it's been around for a decade now. What does willful or deliberate ignorance or reckless disregard look like in that against that requirement?
Sure. So from a legal standpoint, I talked to you already about materiality, right? That whatever has not been done was important, was material to the person who's making the payment decision. Another way that people defend False Claims Act cases is with the state of mind requirement. So the law calls that scienter. And that's just what was your state of mind about this? The law cares about that in the criminal sense. We're used to the idea of, manslaughter versus murder. In the civil side, we don't care that much most of the time. If you hit my car, it doesn't matter if it's because you were drunk or, a bird flew in your window and you were panicking. It doesn't matter. You're liable for the damages, right? That's negligence. That's the negligence standard. So what the False Claims Act requires is different for a civil statute because it is a fraud statute. And that is the one place in the what's fraud, waste, and abuse. I always have to make sure I put that in there. But the fraud requirements under the Federal Rules of Civil Procedure have to be pled up front with particularity. Like we have to give, you can't just say, Eric sold me this car, it was a lemon, he knew it, give me my money back. Right? You have to show how he knew, how he deceived you. You have to give a lot more detail than you do in a typical federal case. And that state of mind requirement in the FCA is more than negligence, right? So negligence won't get you there. I slipped and did this versus all the way to, actual fraudulent intent. So on that spectrum, you can be held liable under the FCA. So your question is, well, how do you prove reckless disregard? How do you prove deliberate ignorance? So those are both terms used. I have another fun, you thought Latin was fun. Here's the word Struthian. Struthian describes the ostrich putting its head in the sand. Do you remember seeing cartoons about that when you were
Of course,
younger?
yeah,
I don't
yeah.
know. So an ostrich, that's being Struthian. And the Supreme Court has used it. So that's how I've encountered it. The only way I've encountered it. But you are being Struthian if you put your head in the sand and refuse to pay any attention to what's going on around you. So I think there was a point, and it may, as you said, depends on when you're counting, where understanding your compliance requirements were kind of this thing out there that nobody understood well, and that smaller companies in particular wouldn't have a cyber professional to elucidate. And maybe you say, well, I had no idea. That's kind of the second piece to this to materiality with the civil cyber fraud initiative is they just did a giant throat clearing and said, ahem, we care about this. Educate yourself. We're going to be taking a look at whether you're compliant with this stuff. So when that's been announced to your industry, how do you say, I didn't know there were requirements? How do you say, I chose not to educate myself? There's too much buzz. The fact that you're doing this interview, right, shows that if you are a concerned and honest broker in this space, you want to know what's going on. You want to know what's required. So I think it would be challenging for a company to show that they were acting in deliberate ignorance, that they were not acting in deliberate ignorance if they just said we had no idea we had to comply with NIST. Now, where you're going to find the margin is in the specific controls. So, for example, you can take an interpretation of a particular control and say, this is what I thought it meant. And I thought it was ambiguous um, at best. And when you get into ambiguity, now you have questions about, well, did you really know better or not? That would be the battleground for proving up that kind of case. And, quite honestly, I think there's plenty of cases that aren't focused on the ambiguity of one or two controls, that again, that's not the kind of case I'm looking for. I'm looking for cases where there's an overall corporate decision not to get compliant, not to self-report, not to move things along, and where there's, national security at risk, where there's real information. Um, I guess another argument on deliberate ignorance, an argument I've heard made is, well, we didn't receive CUI. So why do we have to be compliant on contract X where we never actually received or generated CUI? Well, the rules say if you signed up for this contract, you should be at a level of compliance, at the correct level of compliance, whatever that turns out to be. You had to truthfully tell us what your level of compliance was so we can assess whether, that's good enough. And that's another difficulty in these cases is there's no magic number. So if someone really has a 42 and they say they have a 73 and the government gives them a contract at 73, would they have given them a contract at 42? We don't know. So these are some of the questions where it gets vague in the margins about someone's liability. And, the fewer vague margins there are, the more likely I am to want to bring you to the government's attention.
That's a great way to put it. And boy, you touched on so many things there that I think are so important. One, the idea that it doesn't say that you do or don't have CUI. You're essentially attesting to the fact that you're at a certain level of compliance that related to the ability to handle and process and store, et cetera, controlled unclassified information. And because I hear that all the time, is I don't think I have CUI. It's not marked, and that's really kind of not the point ultimately. And so I appreciate that explanation. And then one of the other things that you mentioned, and just the idea that in this day and age, be it this conference, CMMC Con, the DOJ's initiative around Department of Justice Civil Cyber Fraud Initiative, DFAR 7012, CMMC. There's so much out there. It is, I would imagine, it's strange credibility to be able to say, kind of, you're a defense contractor in this day and age and didn't know there were mandatory minimum cybersecurity requirements. So I appreciate kind of all of that. The other thing that you, I think, touched on, and I know we're getting close to time, and you've been super generous with your time, but I want to make sure we ask this question because ultimately we've talked a lot kind of from the legal perspective, the whistleblower's perspective, but in the context of the False Claims Act, to make an organization care, you mentioned national security and apps, you would hope that would be enough, but we know it's not. So what are the potential legal and financial repercussions for organizations found to have knowingly misrepresented their compliance with DFARS 7012 or soon CMMC? So, like, what are those things, Julie? Because maybe that really, when it comes to the bottom line, that's probably how you make a lot of companies care quickly.
Yeah, and I think that it goes back to the first question about the statute structure, right? So under the False Claims Act, if you have defrauded the government, you've lied to get money or you've lied to keep money you weren't entitled to, then you pay back what you took times three. That's the treble damages provision. You pay the whistleblower if you've retaliated against them. You pay my fees, and there's another which I didn't get to in the first answer, so I'm glad you brought us back to this, the civil money penalty provision. So for every false claim you made, the court shall award, it's not optional, a civil money penalty of, the statute says $5,500 to $11,000. That's on a cost of adjustment based on inflation, and I don't know what it is off the top of my head right now, but let's just use those numbers for tensies. The court decides where between 5,500 and 11,000 they're going to place that your penalty. But it's very possible that these cyber fraud cases could be penalty cases, because how do we assess the damage of not having a proper, in the absence of a breach? How do we assess the damages? And that's a hot topic at the legal conferences that focus on this, as opposed to the cyber conferences that focus on this, because it's in some ways it's just a procurement case. So in a procurement case, the government gets back the value of what it should have received. So there's a couple of different models for damages. They're interesting to lawyer nerds. I'm not sure they're interesting to your. But let's go back to that swing line stapler example, materiality question. So there's a statute that says the Davis-Bacon Act says that you have to pay federal wages at a certain rate if you're doing a federal contract when you're building construction. So there's a case, I think it's called Circle K, where the um, company was hired to build not dormitories, but housing on a army base. I think I'm getting the details okay, but you get the general idea. They're building housing for the military, and they did not pay Davis-Bacon wages. So the question is, did the government get what it paid for? Did it get, it did get housing built. It did not get the one of the reasons government spends money is to enact its policies, right? And it did not get the prevailing wage out. So the cases are kind of all over the map. The first one of these that came out that said, no, pay back the whole cost of that construction. You can imagine that whole area lit up. It was suddenly a trend to file Davis-Bacon cases. And that didn't last very long because that's not exactly right. They did get housing, they did get something for it. So should they have to pay back the whole thing? I'm a relators counsel, and I'm still going to say, I'm not sure that I'm on board with that. My official position, though, if we're opposite each other in a case, is absolutely they should pay every bit of it back. But for the purposes of our discussion, we'll say maybe not. Maybe that's not the most intellectually honest answer from my point of view. Similar case where I do think and I think it's closer an analogy to the cyber fraud cases, is a Jeep brake case. The government contracted for Jeep brakes for its vehicles, and they were supposed to be tested, and the company didn't bother testing them. So they had rashes of failures, and when they realized these had not been tested, they basically had to throw them out. So the court said, yeah, you didn't contract for Jeep brakes. You contracted for tested Jeep brakes that were reliable. And that was such an important part of the contract, so material, that we're going to award full damages. And I think that is right. I think intellectually that is correct. Um, from a point of view of the cyber fraud, it's easier when there's been a breach, like there were Jeep brake failures, but the government's not trying to enact some kind of social policy by having your information kept secure. The government is trying to protect its information, its intellectual property from what we know are very aggressive threat actors. So it's pretty difficult in my mind to say that it's not material, that there's not some damages there. But what's the damages? So some of us in the discussions are positing that the damages would be the cost of compliance, right? If you didn't do these things, and I think this makes a lot of sense from a fairness and equity perspective, because if company A complies and company B does not, company B is in a better financial position. It kept its money, right? So it should have to pay back. Otherwise, it's at a competitive advantage over the company who did the right thing, and that can't be the right answer. So having company B pay back the cost of compliance as the damages, which means it would be times three, would definitely incentivize company C to comply, correct? At least that's the thought. And then I told you these could wind up being penalties cases. Penalties are assessed per false claim. So that's a claim is when you ask the government for money. So in the medical context, that gets debated as to whether that's every patient, is it every time Eric goes to the doctor? Is it every service Eric gets? Is it all the claims that I make at the end of the day? Where we've kind of settled on that in the medical context is you make a claim for payment when you submit it to Medicare. How do you submit that? Do you submit it monthly? Do you submit it, biweekly? That's going to be a claim. And in the cyber fraud context, you're talking about government contracts of some sort where you're going to get paid in some way or another. You're going to either do a drawdown, you're going to do a post where you request money. And when that transaction happens, that's a claim. So, if you're assessed $5,500 to $11,000 per every time you ask for money on a contract, that's another way of looking at how the damages, and that's built into the statute for the exact purpose of it's not okay to defraud the government even if we can't figure out what the damages look like. So, that's another possibility of how things will go. So when you ask me what are the legal and financial repercussions, the answer is I don't know, but they're not good.
Yeah.
They're not good. You
It's,
definitely are better off complying,
yeah.
and it and self-reporting if you're in a position where you're not in compliance and you've come to realize that, right?
Well, what a wonderful way to wrap up. You're definitely better off complying, and I think probably I would agree for sure that the cost of compliance is much more manageable when you're doing it proactively than retroactively. And certainly, as you've shared today, Julie, the perspective from the legal community and your firm, from a potential whistleblower and relator, and from a company potentially, you know, on the other side of cases like this, amazingly valuable perspectives for our audience today. And so I can't thank you enough for all the time that you've given us today and for a session that I think is really meaningful to this audience and a fascinating area of the law. And so Julie Bracker, I want to thank you again. Grateful to have you with our audience today. So thank you very much, Julie.
Thank you. It's a wonderful opportunity to kind of talk to the industry, and I appreciate the chance to share thoughts. There's nothing much you can do to remediate a case once steps have been taken. It's very difficult. So I hope it will, if people are in this situation, if you're a company in this situation, I hope you'll reach out to the government and work as a partner. If you're a potential whistleblower, I hope you'll find me or one of my colleagues and let us kind of coach you through what to do to protect this very important and sensitive information. So
Well said, Julie. Thank you again so much.
thank you.
Thank you, Julie. Your expertise in litigating False Claims Act cases positions you uniquely to provide deep insights into these implications of these legal developments for DIB contractors.